And it's right on like ETV, it's there.
I just went
We had all of our balls and stuff.
All rise.
I didn't want you to say it, so.
Monroe Circuit Court's now in session. Honorable Judge David Williams presiding. Please bow with me for a moment of silent prayer.
Thank you. Everyone be seated.
This is how.
Commonwealth versus Silas Tabor.
Judge Patrick Lanham for Silas Tabor. Mr. Tabor was in Adair County. I had provided the order for the court to sign, have him transported today. He got moved to Todd County either 2 days ago or yesterday. I've spoken with him. Would like to have another. I've now received all discovery and reviewed all discovery the Commonwealth has given. I'd like to have one more
February
negotiation.
19th.
Yeah.
What's your negotiation days?
February 6th at 9 AM.
February 6th at 9 AM.
And then,
Next court appearance would be February the 19th.
okay, thank you, Judge.
Okay, thank you. Kristen Williams.
Your Honor, we did it from us, Williams. We're taking a plea today, Your Honor. Happy New Year to you, sir.
Happy New Year. Are you Kristen Williams?
Yes, sir.
Good morning.
Good morning.
Your birth 1989.
Yes, sir.
Last four digits, social security number 7658.
Yes, sir.
You're here today on a pretrial conference. I understand that you wish to enter a plea. Is that correct?
Yes.
Is it a felony plea?
Yes, it's a diversion plea,
It's
Your
not,
Honor.
okay, it's a diversion. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 25 CR 0046?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed these charges with your attorney, reviewed the evidence, and are you satisfied with his advice?
Yes, sir.
You believe that you've been, do you understand that you do not have to enter a guilty plea today? You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to go over those rights, ask you if you understand, and I will at the end of the list, okay?
Yes, sir.
You have a right not to testify against yourself. No one can make you say anything. Your right to have a speedy trial by jury or be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. The right to produce evidence, the right to call witnesses in your favor and have process issued to compel their attendance. The right to appeal this matter to higher court if you lose, and the right to acquire the Commonwealth to prove beyond a reasonable doubt that you are guilty of charges against you. Understand that by entering a plea today, you give up all those rights.
Yes,
Is
sir.
that correct? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence by law if I allow by law. If I do not accept the Commonwealth's recommendation, decide to impose a harsher punishment, you have a right to withdraw your plea and proceed to trial. Now, I'm going to ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Have you had any felonies the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand that if you fully complete the diversion program, the charges will be dismissed, pre-trial diverted?
Yes, sir.
You understand that if you do not complete the diversion program, you will be brought back in front of the court and scheduled a sentencing hearing. You'll be a convicted felon.
Yes.
That can be used against you in the future. You understand that? Mr. Judd, are you presenting a Commonwealth's recommendation?
Upon a plea of guilty to trafficking and controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 7 years pretrial diverted for 5 years. The defendant shall enter and complete a long-term treatment facility determined by and scheduled through DPA and agreed upon.
Okay, wait a second.
Oh, sorry.
It's a C felony, 7 years. Hit for each other birth.
You're right, I wouldn't think it. We can amend it to 5 or not do the plea.
And to attempt.
Yeah, you could amend it to criminal attempt or trafficking in a D felony, either one.
Yes, those.
I've done diversions in excess of 5 years, but I forgot that was a C. We didn't do it.
Just amend that on there, amended to attempt.
Let's, give me the facts about the charge.
He attempted to facilitate the buy of 5.6 grams of meth and she was caught with it.
But it wasn't completed, Your Honor.
That's what happened. And so I'd initially offered 10 years, served 270 days. You found her in contempt last time because she came here drugged up. So there's no doubt that she's got a drug problem. So I was going to give her the 7 years and do the 180 days and put her in drug court. And I didn't realize, and I just wasn't thinking, sometimes we're not on our A game. So I'll do whatever the court wants, of course.
You put her in drug court,
Yes.
you know, admit it to a D felony.
If that's, that,
Okay, I'll do
still
it.
with 180 days to serve and she had to.
5 years, 180 days served.
Copy of the plea that I have has long-term treatment, no 180-day service. No.
And Your Honor, we're in the process of finding her.
We're not gonna, I'm not.
I guess we
gonna-
just need to start over and do it next month.
Yeah. Okay. I mean, I'm not gonna do a C to a D and no drug court, no this.
Alternative is if she wanted to do a C felony and probate it and let her do long-term treatment, I'll do that. We can do the paperwork. If not, we can start next month on it.
Why isn't drug court a good option for her?
Well, she doesn't have a car. She doesn't have a driver's license, Your Honor. That's the issue. She can't get to drug court.
What's she gonna do when she gets out? If she doesn't have a car and can't get anywhere, is she not gonna work? Is she disabled?
No, she's gonna try to get that, but she's got to get her license back. And I think when can you get your license back? Do you know?
Mayor June,
May or
they were
June?
taken for no insurance.
Well, if she's doing 180 days, that'd put her right around the time she could get her license back and do that.
I'll do a D felony, 180 days and let her do drug court. Maybe she can get her license back by the time she gets into drug court or get near them.
You want to do that or not? Do you want to pass it a month and just, Your Honor, could we pass it a month and
Be fine.
let us
Okay, the days will count that she's there, so.
February 19th?
Negotiation day of February the 9th if you need it, and then the
Or
19th.
6,
Pardon?
6 February.
February 6th and
Six,
February
19th.
19th.
February
Thank you, Your
6th.
Honor.
Okay.
Okay, we'll talk to you.
Okay. Nicholas Burge. Are you Nicholas Burge? Good morning. Were you born in 1985? Last 4 digits, social security number 3658. You here with purpose of arraignment. You have a right to remain silent. You're represented by Mr. Bell. The grand jury, Monroe County has charged you with assault in the 2nd degree and being a persistent felony offender. You understand what those charges are? Mr. Bell, do you acknowledge the identity of your client, received the indictment, waive formal reading and arraignment, enter a plea of not guilty, reserving all pretrial motions?
Yes, sir.
We set a negotiation day for February the 6th and the next court date for February 19th. There's any complaints about this gentleman's bond?
As long as there's convictions, no contact with victim.
Okay. Sign a reciprocal discovery order. Says the Commonwealth provide your attorney some information to prepare you. Okay?
Thank you, Judge.
Okay. Mr. Bell, are you gonna be around for a while?
Yes, sir.
Kelly, Judge Kelly Easton of the Court of Appeals is gonna be down here around 11 o'clock, and he said he'd like to meet some of the local lawyers if you're still around, if you're Terrians by then. Okay?
Yes, sir. I'll do that, Judge. Thank you.
Yeah. Jeffrey Blakely. Jeffrey Blakely. Are you Jeffrey Blakely?
Yes, sir.
Good morning. We're here on 25 CR 0068. Were you born in 1988?
Yes, sir.
Last four digits, social security number 4210.
Yes, sir.
You're here for the purpose of arraignment. Do you have an attorney?
No, not yet.
No. Can you afford an attorney?
No.
Okay, well, we'll have to let you do an affidavit. I'm gonna let public advocacy stand in for the purpose of arraignment right now. And then you can fill an affidavit out to see if we make the permanent. You acknowledge Mr. Blakely's identity? Acknowledge, you heard him acknowledge his identity, Counselor?
Oh, I believe so, Your Honor.
Well, are you Jeffrey Blakely?
Jeffrey C. Blakely?
Yeah, were you born in 1988?
Yes, sir.
Last four digits, social security number 4210.
Yes, sir.
Grand jury, you have a right to remain silent, represented by counsel for purposes. The grand jury of Monroe County has returned an indictment charging you with criminal mischief in a first degree, burglary in third degree. You understand what those charges are? Okay. Now you acknowledge receipt of indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order that requires the Commonwealth to give you certain information to help you prepare for your defense, Mr. Blakely. What is his bond?
Just started this morning.
Yeah. I don't know what the bond on the indictment warrant was. Where do you live, Mr. Blakely?
23 Park Carter Road.
It's 20,000 Clark Pollution. 20,000 Clark Pollution.
Yeah, your bond is 20,000 clerk approved surety. It shouldn't be hard to get somebody to make that for you. They don't have to put any money up or anything. I'll leave the bond the same. February 6th for a negotiation day in February the 19th. Next court appearance. You need to go over here with a pretrial and fill out an affidavit, see if I can appoint a public defender for you full time, okay?
Thank you, Your Honor.
Yeah. Catherine Carmichael. Catherine Carmichael. 25 CR 0075. For any of the lawyers that are here today, Judge Kelly Easton is going to be here at 11 o'clock. Monroe County has now been moved over into the Supreme Court District with Bowling Green and Glasgow, and he was going to come down here today. So all of you are welcome. We'll take a brief pause at 11 and let him introduce himself here. He's going to come and make himself welcome in Monroe County. Are you Catherine Carmichael?
Yes, sir.
You born in 1982?
92.
92?
Yes, sir.
Yeah. The last four digits, social security number 5220.
Yes, sir.
You have an attorney here today?
No, sir.
What's the deal here? Can you not afford an attorney or?
No, I can. I was waiting to be arranged so I could start looking and kind of figuring out where I needed to go from there as far as hiring it.
Yeah. Next time if you ever get indicted again, it's good to start figuring out before you come up here. For the purpose of arraignment, I'm going to let the public advocacy office stand in. You have a right to remain silent. If you have any questions, you can step us back and ask her, okay? The grand jury of Monroe County has returned an indictment charging you with possession of controlled substance in the first degree, third or greater offense. Possession of marijuana, possession of drug paraphernalia, tampering with physical evidence, being a persistent felony offender. You understand those charges?
Yes, sir.
Counselor, you acknowledge the identity of Ms. Carmichael, receipt of the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order. I will let when you get are you gonna get a private attorney, you think?
Yeah,
Okay, well, you need the private attorney to contact the Commonwealth Attorney's Office to get this discovery information about your case.
Okay.
And, you need to be present with your attorney on February the 6th here at 9 a.m. for negotiations, and your next court date is February the 19th, okay? You can just give her the indictments if you want to. Great. Thank you.
Thank you.
Yeah. Jonathan Clark. Commonwealth versus Jonathan Clark. Now there's an active warrant out for Mr. Clark. Is that correct?
Been served, Your Honor.
He's been served this morning. Did you take him into custody or?
No, he served.
Hey, 4 years, yeah.
Okay, that's okay. Mr. Clark, were you born in 1974?
Yes, sir.
Last four digits, social security number 6109.
Yes, sir.
We're here on 25 CR 0076 for arraignment. Do you have an attorney?
No, I don't.
Did you?
I'm in talks with one, but it ain't guaranteed yet.
Okay, well, I'll ask public advocacy to stand in for the purpose of your arraignment, okay? Now, you think you can afford an attorney or you know yet?
It depends on how much they want.
Well, that's always true. If it's $1 million, you probably can't afford it. $10, probably you get Mr. Carter for $10. You give in Mr. Carter for $10? Well, you've lost him for 10. I guess it's,
I probably can't.
The problem you're gonna have, Your Honor, is Mr. Carmichael, Mr. Clark, and William Underwood are all co-defendants.
yeah, you're gonna
So
have conflict.
they're coming here and they say they're gonna give them attorneys, and if they don't get one, then DPA is probably gonna get conflict counsel.
Yeah, well, I'm going ahead and have you fill out an affidavit here, for public advocacy to see if you're qualified to get conflict counsel going. You have right to remain silent. The grand jury of, Monroe County's returned an indictment charging you with possession of controlled substance, first degree, third or greater offense, possession of marijuana, possession of drug paraphernalia, tampering with physical evidence, being a persistent felon offender. You understand those charges?
Yes, sir.
Counselor, do you acknowledge the receipt of the indictment, the identity of your client, waive formal reading and arraignment, enter plea of not guilty, reserving all
Yes, sir.
pretrial motions? I'm signing a reciprocal discovery order here. Requires them to do that. You take a seat here somewhere when we finish with you. And he'll do an affidavit to see if I can permanently appoint public advocacy to represent you. You be here on February the 6th at 9 a.m. for negotiation. And if you don't qualify for public advocate, you need to have a lawyer here that day. And then on the 19th, you'll need to be back here. So the 6th for negotiation, 19th the next court date. Okay? Yeah, Mr. Blakely is qualified for a public defender. Grady Jones. Grady Jones.
Morning, Judge.
Morning.
Judge, I don't know if he was transported from the facility. Which facility was he in?
I don't know, probation, parole seemed to look long-term rehab.
Yeah, I think we seen him in the healing place.
Yeah. And I had spoken with Mr. Stockton. If we can set this over to the February date, I attended the conference to try to negotiate, but we can set it over one date.
Yeah, one day, if he don't enter a play next time, we'll be getting a trial.
What's he charged with?
He's charged with trafficking. The hangup is he's got a 20-year sentence from a jury trial and still got 12 years left on his parole. So I don't anticipate anything other than the trial, because if he's convicted, he's gonna have to serve out. He's gonna have his parole revoked. And while all this was pending, I think the parole board or somebody sent him to long-term treatment. I don't know what happened. So,
How did he slip through us not getting him transported? Did you not get him transported?
Judge, I didn't do a transport order. I just gotten in the case like Thursday of last week.
February the 6th for negotiation, February 19th.
maybe Mr. Garrett can make arrangements to have his client present. Okay.
Joshua Pettigo. What kind of bond let's wait just a second. What kind of bond did I set on Mr. Jones? I don't really know how I've got somebody out loose that's got 12 or 13 years on the shelf and I got him loose on a bond. What kind of bond?
$20,000 for a registered.
And he made that? Well, we'll revisit that.
He's been on that bond since September 26th.
Yeah, he first had public advocate. He's just kind of been playing the system and delaying the case, but it's not gonna be delayed much longer.
Okay. You're Joshua Pettigo.
Yes, sir.
Good morning. You're on 25 CR 0073. Were you born in 1986?
Yes, sir.
Last four digits, social security number 4930.
Yes,
Do you have an attorney?
not yet. I'm gonna hire one though. I didn't know I needed one today. I thought this was where you would ask.
For the purpose of arraignment, I'm gonna let public advocates stay in. You have a right to remain silent. The grand jury of Monroe County has charged you with trafficking controlled substance first degree, possession of controlled substance in the second degree, and possession of controlled substance not in the original container. You understand those charges? Counselor, do you acknowledge the identity of Mr. Pettigo, the fact that you've received indictments, waived formal reading and arraignment, and a plea of not guilty for serving all pretrial motions?
Yes, Your Honor.
Mr. Pettigo, I'm signing a reciprocal discovery order that requires the Commonwealth to provide information you concerning preparation of your case. You be with an attorney here February the 6th at 9 a.m. for negotiation. February 19th is your next court appearance. You need to have attorneys there. I'm not going to tarry
I'm
with
gonna
this.
talk to Nick as soon as I get done here.
Okay, that'll be fine. Thank you. Stay on the same bond. Rhonda Shinning. Catherine Carmichael qualifies for public advocate.
Arrangements on her hire.
Yeah. Catherine Carmichael. Okay, well, I'll go ahead and appoint public advocate next time. I won't do it this time. I'll just keep the affidavit. Just put that affidavit in the file. I won't sign the order. Are you Rhonda Shinning? Is that how you say your last name?
Yes, sir.
Okay. This 25 CR 0060. Were you born in 1976?
Yes,
Last four digits, social security number 8929.
Yes, sir.
You're here for a pretrial conference today. You're represented by the Office of Public Advocacy. What do we have going on here?
We have a pretrial diversion, Your Honor.
Okay. Just been informed a motion has been tendered that says you wish to enter a plea today. Is that correct? Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person that we just identified in 25 CR 0060?
Yes, sir.
Is your judgment impaired today in
No,
any way?
sir.
Have you discussed the charges with your attorney, and are you satisfied with her advice?
Yes, sir.
You believe you're fully informed about the case. You reviewed the evidence. Is that
Yes, sir.
correct? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept this plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your trial, the right to confront and cross-examine all witnesses called to testify against you, right to fix evidence, right to call witnesses in your favor and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose, and a right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. Understand it, but entering guilty plea today, you give up all those rights.
Yes, sir.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept any recommendation. In the event I don't accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Yes, sir.
I'm gonna ask you some qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Had any felonies in the past 10 years?
No, sir.
Are you currently on probation?
No, sir.
You understand if you complete the diversion program, the charges will be dismissed, pretrial diverted, and you can have them expunged. You understand that? But if
Yes,
you
sir.
don't successfully complete it, and you're brought back in front of me and I revoke your pretrial diversion, schedule a sentencing hearing, you'll be a convicted felon, and that could be used against you in the future. You understand that? Mr. Judd, are you presenting?
The Commonwealth agrees to dismiss possession of drug paraphernalia, which is a class A misdemeanor. Upon the plea of guilty to possession of controlled substance, first degree methamphetamine, the defendant shall receive a sentence of 3 years pretrial diverted for 5 years supervised. The defendant shall receive credit for time served. The defendant shall be referred to the social service clinician and following any and all recommendations of the clinician. The defendant agrees to have any and all evidence above case forfeited and destroyed in a manner consistent with the laws of the Commonwealth of Kentucky. It is understood that this offer as made by the Commonwealth is not binding upon the Commonwealth until signed by his attorney. It's effective on that.
Is that what you agreed to?
Yes, sir.
Are you pleading guilty to the indictment as amended? Because you did commit the acts charged in the indictment.
Yes, sir.
Doing so of your own free will.
Yes, sir.
Your constitutional rights have explained it to us is still your desire to proceed with a plea and allow the court to fix your punishment within the range permitted by law. Is that correct?
Yes, sir.
Is that your signature on the motion and offer?
Yes, sir.
I'll accept the agreement, sign the diversion order. What's the court cost in this case? You need some time to pay that?
Yes, sir.
I'll just pay it $30 a month. The first payment due 30 days from today. That'll get you time to get on your feet a little bit, okay?
Yes, sir.
You need to meet with the probation parole officer right there. Robert Simpson. Commonwealth versus Robert Simpson, 24 AD, 24 CR rather, 0079. You are Robert Simpson?
Yes.
Born in 1991?
Yes, sir.
Last 4 digits, social security number 5031. Is that correct? Representing Mr. Carter. Have you had an opportunity to review the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Mr. Carter, is there any reason this gentleman should not be sentenced?
No, Your Honor.
Or plead guilty to trafficking controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 5 years, probated for 5 years, shall receive credit for time served, shall have employment. Are you employed now?
Yes, sir.
Simpson Farm.
Okay. All evidence would be destroyed. Court costs $240. You need some time to pay the court costs. I'll let you pay it $30 a month. The first payment due 30 days from today, okay?
Thank you.
You meet with the probation parole officer. William Underwood. 25 CR 0074. Are you William Underwood? Good morning.
Morning.
Were you born in 1974?
Yes, sir.
Last 4 digits, social security number 6911.
Yes, sir.
You were here for the purpose of arraignment. Do you have an attorney?
No, sir, I
Are
can't
you-
afford one.
Okay, well, have you filled out an affidavit yet?
No, I haven't.
Well, I'm
I have
gonna
one
go-
with me here.
Did they have public defender in district court for you here? I'll continue that appointment. You're here for arraignment. You have a right to remain silent. This is your attorney here. The grand jury of Monroe County has returned an indictment charging possession of controlled substance first degree, possession of marijuana, possession of drug paraphernalia, operating under the influence, failure to use a seatbelt, no insurance. Expired plates. No plate on. No license possession, failure to signal. Do you understand those? Counselor, you acknowledge the identity of your client, proceed indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions. Okay, I'm signing a reciprocal discovery order here, Mr. Underwood, that requires the Commonwealth to give your attorney information to help you prepare for your defense. You need to be back here on February the 6th at 9 a.m. for negotiation and February the 19th for your next court appearance. There are no complaints about your bond. You can stay out on same bond. I want you to how'd you get here today? Did you drive?
No, I'm here from Monroe.
You don't need to be driving. Stay, you don't have any license, have any insurance. Just make sure you don't drive.
I've got license here. You don't have to say anything.
You got license now? City has license now, so I might not have the restriction on there if he has license now. Would you step back and ask him if he has license now?
You are condition of your phone, you've been in trouble.
Your Honor, he has a current license.
Yeah. Well, let's just him not be driving until we get down the road on this a little bit more. So it's conditioning your mind not to drive, okay? Okay. February the 6th, February 19th. Okay, is there anyone else here in the courtroom that needs to come in front of the court? What's your name? I kind of felt that was gonna be the case, so. Okay, we had you in jail. Come on up here. Did you make a bond, Ashley, or did you escape? Okay, come on up and. Commonwealth versus Ashley Bishop, 25 CR 0072. You are Ashley Bishop, born in 1989. Last four digits, social security number 6619. Do you have an attorney?
No.
The public advocates represent you in district court, or did it go to district court?
I'm sorry.
Were you in Judge Christie's court? Were you?
I've never been to court. This is the first time I've been to court.
Well, welcome. We're glad to have you. Hey, can you afford an attorney? Okay, so you need to fill out an affidavit here,
Okay.
and I'm gonna let public advocacy step in until then. You have a right to remain silent, okay? The grand jury of Monroe County has returned an indictment charging you with theft, unlawful taking or disposition, theft by deception, and theft by failure to make required disposition. You understand what the charges are? Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
I'm signing a reciprocal discovery order here, Ms. Bishop, that requires the Commonwealth to give you information for the preparation of your defense. You'll be here on February 6th at 9 a.m. for negotiation, and February 19th for your next court date. You need to get the contact information for your attorney. You need to step over here and fill out an affidavit, see about your eligibility for public advocate. Is there anybody else here? Yeah, we got another hand up. Come on up. Come on up. What do you have? You what?
I was a demon savior for a hearing.
Mr. Stockton?
Yeah.
You know anything?
He's on the Barron County Jail docket.
You know, why was she subpoenaed?
Who's this? Which case we're on? Cause she's a witness in the case where he allegedly assaulted her.
Okay. So when y'all want to talk to her first or have?
Yeah, we're kind of shorthanded. Right? Mr. Huntley might be able to talk to her and then it gets filed. I know what. Amber stepped out on another case that we're
Okay.
dealing with.
They'll come back and talk to you, okay?
It's fine.
Brian Hunter.
Okay, let's go to Barron County.
They're not scheduled to be here.
Barron County's not scheduled till 10:30. Okay, well, let's go off the record just for a second.
Yeah. It's more cases than one. It's on the litigation.
Okay, let's come back to order. We'll call the Barron County Detention Jail docket. Commonwealth Work versus Ricky Birdwell. Commonwealth versus Ricky Birdwell. Are you Ricky Birdwell?
Yes.
Good morning. Were you born in 1979?
Yes.
Last four digits of your social security number, 0838.
Yes.
You're represented by Mr. Johnny Bell. Mr. Bell?
Yes, sir, Judge.
We're here for a pretrial conference. What do you have?
We got a felony plea.
Okay. Ms. Birdwell, I've just been informed that you wish to enter a plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No.
Plead freely and voluntarily given.
Yes.
Are you the same person that we just identified in 25 CR 0053? Is your judgment impaired today in any way?
No.
You discussed this matter with your attorney, reviewed the evidence, you feel like you're fully informed, are you satisfied with his advice?
Yes.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. And I'm gonna go over the rights and ask you if you understand. Okay, you have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, the right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, the right to call witnesses in your favor, and process issue to compel their attendance. You have a right to appeal this matter to higher court if you lose, or right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charges against you. You understand that by entering a guilty plea today, you waive those rights. You understand that?
Yes.
Now, I may consider the Commonwealth's recommendation, but I may apply or impose any sentence that's allowed by law. Prior to accepting any recommendation, I will order a pre-sentence investigation report to be done by probation and parole. In the event I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Mr. Judd, what is the Commonwealth's recommendation?
Your Honor, please, the Commonwealth agrees to dismiss three different charges. The first one is possession of controlled substance, first degree, first offense, methamphetamine. Second is possession of drug paraphernalia, and the third is possession of marijuana. Upon the plea of guilty, the Commonwealth agrees. Upon the plea of guilty to trafficking and controlled substance, rather first degree, first offense, methamphetamine, it's over 2 grams. The defendant shall receive a sentence of 5 years probated for 5 years supervised. The defendant shall enter and complete the Monroe Specialty Court. The defendant shall remain incarcerated until the morning of orientation. The defendant shall receive credit for time served. The defendant shall obtain gainful employment or do a minimum of 30 hours community service per week until gainful employment is attained. The defendant agrees to have any and all evidence in the above cases disposed of in the manner with the laws of the Commonwealth and the holding agency.
Is that your understanding, ma'am, of the Commonwealth's recommendation?
Yes.
Are you pleading guilty to this amended indictment because you did commit the acts charged in the amended indictment?
Yes.
You're going to serve your own free will.
Yes.
On your constitutional rights to explain to still your desire to proceed with the guilty plea and allow the court to fix your punishment within the range permitted by law.
Yes.
Understand that because of this plea, any future convictions could be enhanced under persistent felony offender law as far as range of sentence. You understand that?
Yes.
I'm gonna hold this signature up here. Is that your signature there, ma'am?
Yes.
Well, I'll accept the plea. I'll accept the plea. And order a pre-sentence investigation report to be done by probation and parole and schedule your sentencing for February the 19th.
Judge, if I could very briefly, I had contacted Mr. Stockton and provided him with a lot of medical records, concerning, Miss Birdwell's health, and we had talked about, I don't know what his position now
Well,
is.
her mother called me, I believe it was her mother, and I looked at the records. And I don't really want to say what her condition is. You know, I like to approach.
Okay.
Well, y'all just need to discuss that with each other sometime and.
The record, that's not serious, no.
Okay.
Okay.
Well, Judge, we had also called drug court and tried to get her evaluated, but they'd switched it around somehow.
We're gonna have a pre-sentence investigation report done in signature on the 19th.
All right, Judge, thank you.
You know, we do it on, we just can't
understand.
deviate from that, you know.
Yes, sir.
Okay. Commonwealth versus Matthew Bowles. Are you Matthew Bowles?
Yes, sir.
Morning. We're here on 24 CR 008. Mr. Bowles, were you born in 1989?
Yes.
Last four digits, social security number 5713, is that correct?
Yes.
And we're here for sentencing today. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
It's substantially correct.
Yes.
Counselor, is there any reason he should not be sentenced today?
No, Your Honor.
On a plea of guilty to flagrant unsupported, he should receive 5 years, probated for 5 years. The defendant shall pay child support in the amount of $13,142.29 at a monthly rate, $206.50 plus an additional $150 to be applied toward arrearage for a total monthly payment of $356.50. All payments shall be paid to Letitia Sherfy first and then to thereafter be paid to Division of Child Support. Supervision shall continue until the arrears are paid in full. He shall receive credit for time served and shall be released upon final sentencing, which is today. What are the court costs? $185. Do you need some time to pay the $185, sir?
Yes.
Now let's pay, in addition to your other child support payments, you can pay $30 a month toward the $185. The first payment, those start in 30 days from today to give you an opportunity to on your feet, okay?
Okay.
Now, probation parole, when can y'all meet?
Monday morning, Your Honor, in Glasgow.
Okay, and do you know where the probation parole office is in Glasgow?
Yes.
We're gonna release him today, is that correct? We'll go ahead and release you today, and you be there at maybe 9 o'clock on Monday morning, probation parole, okay?
He lives out of state. I think we got him on NCIC. The only thing I'm concerned about, if we wait till Monday to have him meet with probation parole, does he have a place to stay up here or anything?
Can y'all meet with him this afternoon?
For Friday, maybe?
Your Honor, I can see that I can make arrangements to see him Friday morning at 9 o'clock.
Okay, what we'll do then is we'll just, you stay in jail tonight and he'll meet with you, come over and meet, and you get out in the morning, okay? And that way, if you got somebody come pick you up out of state, wherever you know, they won't have to wait overnight, okay?
All right.
Okay, thank you very much. George Brown. Commonwealth Kentucky versus George Brown, 24 CR 0050, 17 CR 0088. Are you George Brown?
Yes.
Good morning. You born in 1994?
Yes.
Last four digits, security number 2561. You're here on revocation. What does the Commonwealth have to say?
He has a 3-year sentence on possession. He recently got a charge for shoplifting at Bucky's, and I don't know what county that is, if it's Warren County or what. I'll have to look at the citation.
Yeah.
That's the basis of the revocation.
And Your Honor, we're gonna have to conflict him out. I met with him yesterday.
I can't hear you, man.
Your Honor, we're gonna have to conflict him out. Met with him yesterday, determined that there is an active conflict. And so if we could reset.
What would be the conflict?
Bad approach.
Well, yeah, Commonwealth, come over here. I mean, we're broadcasting. Just tell him what the conflict is.
Okay, he did that.
Do what? So we want to get him another lawyer?
That's correct, Your Honor.
Okay, will you have him here on negotiation day or
Yeah, if I can get the conflict lawyer here negotiating.
conflict on negotiation day on February the 6th and then on February the 19th with your two court dates. They're going to have to get you a new lawyer. There's some kind of conflict, so you'll have someone that can give you independent advice, sir, okay?
Okay.
Okay, thank
Yes,
you.
sir.
Thank you very much. Matthew Burkhead. Matthew Burkhead.
Yes, sir.
Are you Matthew Burkhead?
Yes, sir.
Morning. You're here today on 21 CR 00110. Were you born in 1993, Mr. Burkhead?
Yes, sir.
And the last four digits, social security number 6665. You're here on a
Sir.
probation revocation. What does the comma have to
Yeah.
say?
He has a 5-year sentence that he's on probation for possession of a firearm by convicted felon. And he's being supervised out of this area, and he picked up a new felony arrest in Hardin County for possession. So the Commonwealth filed a motion. Now, the probation officer is unavailable for today. We'd have to get another date.
And Your Honor, I spoke with Mr.
Can you speak
Stockton.
up, please?
Spoke with Mr. Stockton. I was under the assumption that we would be able to do an offer in lieu of revocation, which would be or alternative sentence worker to assess him for treatment.
Yeah, I think we probably need to set it for negotiation day so I can see the Hardin County case.
Negotiation date will be on February the 6th, the next court date, February 19th. Your attorney will be able to talk to you and see if they can work something out short of revocation, okay? Thank you very much.
At court in Hardin County next week.
Come back, I didn't hear you. What'd you say?
This court in Hardin County next week.
Yes,
Okay.
sir.
Need to talk to your attorney about a transportation order or something if they need to go up there. If that's on the shoplifting charge or,
No, heck no, it's not me.
And it's a preliminary hearing.
preliminary hearing you got there, well, you'll need to be. Does he have a public advocate up there?
I believe he does.
Okay. Will you contact that public advocate and see if you can get this gentleman a transport order if they need one?
Yes, sir.
Okay, we'll try to take care of it. Okay, thank you.
Appreciate it.
Yeah. Oh, Burks and everything. Christopher Burks. Commonwealth versus Christopher Burks, 25 CR 0051. Are you Christopher Burks?
Yes.
Morning. Were you born in 1994 and the last four digits, social security number 8386? Is that correct?
Yeah.
And you're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes.
Is it substantially correct?
Yeah.
Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
Upon plea of guilty to pleading evading police, first degree class C felony, he shall receive 6 years to serve. Is that the only charge?
Yes, Your Honor.
The other charges seem to have been dismissed. What are the court costs in here?
165.
165. If you got 6 years to serve, I'm going to waive the court cost on it. Okay? Thank you. Thank you very much. Willie Daniels. How are you, Willie Daniels?
Yes, sir.
Morning. This is 25 CR 0058 Commonwealth Kentucky versus Willie Daniels. Were you born in 1997?
Yes, sir.
Last four digits of your social security number 2134.
Yeah.
We're here for a pretrial conference. Mr. Bell, what do you have in this?
Judge, I was just retained on this morning by his grandmother. He's got one case here and one pending in the box. I would ask for another conference day if we could to try to get both of those maybe worked out the
In
same
the
day.
box? What does that mean? I'm not familiar.
He's not been indicted yet.
Oh,
It's like a baseball analogy, I guess.
yeah.
Next
On
up.
deck, maybe.
Yeah, on deck. There you go.
One on deck and the third one in the hole. I'd rather be in the box than the hole. Let's do that right
And
now.
Judge, I just want to make sure that I'm released on this because this has gone back and forth a couple times. So I just want to be officially that Mr. Bell is in and I'm out.
Mr. Bell,
Yes, sir.
if this fine attorney here withdraws, she wants to make sure that you don't change your mind.
I'm not gonna change my mind. Judge.
And
All right.
I'm not gonna change my mind either. You're in.
Yes, sir.
Okay,
Thank you, Judge. Have a good one.
thank you. You have do a transportation order, get your client here on the 6th for negotiation and on the 19th for next court appearance.
Yes, sir, Judge.
Your attorney will be over to see you, sir.
I will.
Brian Elliott. Brian Elliott.
Yeah.
Are you Brian Elliott?
Yeah.
Good morning. This is 19 CR 00123 Commonwealth of Kentucky versus Brian Elliott. Mr. Elliott, were you born in 1976?
Yes.
Last 4 digits, social security number 1403.
Correct. Yes.
This is a pretrial diversion revocation. Is that correct?
Yes, sir.
I mean, this is a 19 case, I guess.
It's been going around a while.
Yeah, what do you got
He's
here?
had, in lieu of, I think, revocations. He was at Owensboro Regional,
Speak up just a little.
he was at the Owensboro Regional Recovery. He was discharged for various reasons and didn't report and had a positive drug test. And so we're asking for revocation of the verdict.
Your Honor, we would stipulate to the violations at this time. We would just ask for the court to allow him one more chance to remain on his pretrial diversion and allow us to arrange a new long-term treatment program for him.
Well, I don't know anything about the case, so I'm not gonna make it. If you stipulate to the charges, come around here again. What were the charges?
Well, he was at Owensboro Regional Recovery on, he was discharged on 12/23/25 because he violated their building curfew, failed to report for job duty, which was cleaning. He was eavesdropping on some other clients, and then he tested positive for hydroxybutropine, which I had to look up, which is the scientific name for Wellbutrin. So, and he was discharged for those reasons. And I don't think he called into Mr. Collins, he after he was discharged. He was being supervised by Officer Everly. Oh, Everly. And I could ask Officer Everly if he reported after that. I don't know if he did.
Officer Everly?
Yeah, Jason Everly.
Jason, are you on there? Will you raise your right hand, please? Swear the testimony you're about to give is the truth, the whole truth, nothing but the truth.
I do.
And you may inquire for the Commonwealth.
Officer Everly, how long have you been supervising Mr. Elliott?
He had initially made it to OR September 24th, 2025. So it was about 3 months.
You were only supervising him because he was referred over to Owensboro Regional.
That is correct.
That's correct. When he was discharged from there, did he report to you?
He did not. He alleged that he had to go to the hospital. He was told to report immediately to Barron County Probation and Parole. He didn't end up doing that. He eventually had went back home to wherever it is that he was from. And I think that was Laurel County. And then I spoke with his dad and told him to report immediately to the Laurel County Probation and Parole Office. And he ended up going at that point, and then he was taken into custody per the directive of Judge Williams.
Okay, I have no other questions.
Like to inquire this often.
Officer Everly, just to be, just so that I'm clear, after he was discharged from the program, so it looked like he had been discharged on 12/23. Is that correct?
That is correct.
Okay. And he was told there before he reported to the Laurel County Probation Office that he needed to report there?
No, it was he was advised 7:30 that morning. I was told when this is because it happened before we had opened. Owensboro Regional Recovery staff advised him to report immediately to Barron County Probation and Parole.
Okay. And he did not report to the Barron County Probation and Parole?
That is correct.
Okay. Was there any reason given why he did not report at that time?
He was saying that he was sick and wasn't able to go. He went home. I made contact with his dad the next morning. They were asking for him to stay with them during the Christmas weekend and then have him report on Monday. I told him that was not the case. He needed to report immediately. to probation and parole, because he was already back in Laurel County. He was directed to report to the Laurel County Probation and Parole Office, or I directed the dad to have him report there. And the dad got him out of bed and took him to that office.
Okay, so he did report immediately to the Laurel County Probation Office?
After my conversation with him.
Okay. All right, I have no other
What was
questions.
the original? He entered a plea in September 2020. What was?
I think it was a possession. It's just one of these that's drug on forever where there's been so many violations and things.
A trafficking and down to a possession.
That's correct. So I just think he needs to be revoked, sentenced. He's had every opportunity to try to get out this stuff, but it's been.
If I sentence him, he could still be he'd be up for shock.
That's correct.
Okay, well, I'm gonna go ahead and revoke, and I want you to get a plan together
Yes, sir.
and send it to the Commonwealth. Mr. Elliott, I don't necessarily want to have you to serve your entire time out. I'm gonna go ahead and revoke you because of the evidence, but your attorney will be over to talk to you to see if we can look at a shock probation as soon as you're eligible for it, to see if there can be a plan, give you an opportunity to perform. Doesn't look hopeful, but I don't give up on anybody, and I'm not gonna give up on you, so you work with it. Okay?
All right.
Thank
All
you.
right.
Thank you.
you.
What?
You just can't go up for sentence.
The sentencing will be on February the 19th. And, okay, thank you. James Farber. James Farber. Are you James Farber?
Yes, sir.
Okay, good morning. This is 25 CR 0059. Mr. Farber, were you born in 1994?
Sure.
Last four digits social security number 0603. We're here for a pretrial conference. What do you have?
Your Honor, we have a felony plea.
Mr. Farber, I've just been informed that you wish to enter a plea today. Is that correct?
Yeah.
Are you currently under the influence of drugs or alcohol?
I am.
Is this plea freely and voluntarily given?
Yes.
Are you the same person that we just identified in 25 CR 0059?
Yes.
Is your judgment impaired today in any way?
No.
You know what's going on? Is your judgment impaired? Have you discussed these charges with your attorney? Are you satisfied with her advice?
Yeah.
Okay, you believe you're fully informed about your case?
Yeah.
Okay, you understand that you do not have to plead guilty today. You have certain rights under the Kentucky and United States Constitution. Before I can accept a plea, I need to know that you understand those rights. I'm gonna go over them here, and at the end, I'm gonna ask if you do. Okay, you have the right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. The right to call witnesses in your favor, have process issued to compel their attendance, the right to produce evidence, the right to appeal this matter to higher court if you lose, the right to require the Commonwealth to prove on a reasonable doubt that you're guilty of charges against you. You understand that by entering a plea of guilty today, you give up all those rights. You understand that?
Yes, sir.
Now, I may consider a Commonwealth's recommendation, but I may apply a range of sentence provided by law. Prior to accepting the recommendation, I will await the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea and go to trial. Mr. Judd, what is the Commonwealth's recommendation?
The Commonwealth recommends the following amendment and or dismissal without prejudice of the following charges. First, dismiss possession of drug paraphernalia and persistent felony offender, second degree enhancement. To amend operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substance, second offense aggravating circumstances. To operating a motor vehicle with alcohol concentration concentration of or above 0.08 or while under the influence of alcohol or other substances, second offense. Upon a plea of guilty to operating a motor vehicle with alcohol concentration of or above 0.08 or while under the influence of alcohol or other substance, second offense, the defendant shall receive 7 days in jail and pay a $300 fine plus cost. Upon a plea of guilty of possession of controlled substance, first degree, second offense, the defendant shall receive a sentence of 2 years. Upon a plea of guilty to tampering with physical evidence, the defendant shall receive a sentence of 4 years. The 2-year sentence and the 4-year sentence shall run consecutively for a total of 6 years, probated for 5 years, supervised. The defendant shall enter and complete a long-term rehab facility determined by and through DPA and agreed upon by the Commonwealth. The defendant shall remain incarcerated until the morning of the bed date and shall be transported by probation parole. The defendant shall testify truthfully in the case of Commonwealth versus Willie Daniels, Monroe indictment number 25 CR 00058. The defendant shall receive credit for time served. The defendant agrees to have any and all evidence above case disposed in manner consistent with the laws of the Commonwealth and holding agency.
Is that what you agreed to, sir?
Yes, Your Honor.
Are you pleading guilty because you did commit the acts charged in the amended indictment? Knowing your constitutional rights have explained, is it still your desire to give those rights, allow the court to fix your punishment as permitted by law? Is that correct?
Yes, Your Honor.
Now, you understand that the DUI is enhanceable if you get another DUI, and the felony conviction is enhanceable if you get another felony conviction. The penalty for either one of those could be more. Do you understand that?
Yes, Your Honor.
Can we hand me the document up here and let him identify his signature? Thank you. Is that your signature on there, sir?
Yes, Your Honor.
Okay. Well, I accept the agreement order pre-sentence investigation report to them probation, parole, and schedule for sentencing on February the 19th. Okay. Thank you. Keith Golliser. Is that how you pronounce your name, sir? Golliser, or is it Galliser?
Galliser, Your Honor.
Commonwealth, good morning. Commonwealth versus Keith Galliser. 18 CR 0007. Mr. Galliser, were you born in 1991?
Yes, sir.
That's 4-digit social security number 4306. You're here on a probation revocation and you're represented by Mr. Ken Garrett. What does the Commonwealth have to say?
Your Honor, I think Mr. Galliser was indicted in 2018. He was placed in NCIC in 2019. He's finally in front of the court. Sometime during the interim, the prosecuting witness or the alleged victim in this case went to the Monroe County Child Support Office and waived all the arrearage, which was approximately $17,000. He still owed $4,000 to the state. I think he set up arrangements to take that. I don't know what the solution is. You try to prosecute these cases and people change their mind. I guess I'm gonna start having everybody that wants to prosecute a child support case come to the grand jury because that's a whole lot of trouble putting in.
So he was picked up at NCIC.
That's correct.
What do you have to say?
He turned himself in, Judge. He has paid that other amount. I think it was
4,000 and something.
$3,000 or a little better than that. He's already paid that, and there's a receipt from.
How long has he been in jail this time?
Keith, how many days have you been in jail?
I turned myself in Monday morning to make this court date.
The Commonwealth's withdrawn the motion to revoke. I just don't know what the solution is. I guess we're gonna have to go back to all of our files and make sure that people want to prosecute their case.
Well, let me come around here. Let me talk to you about this case here. So he turned himself in.
Well, evidently they must be
on Monday, so
there must be some collusion going on somewhere. He knew it was waived, so he's been on the run for 6 years, but he turns himself in. It's all kind of fishy smelling to me. I don't know. I kind of get skeptical after being in this job for 20 some odd years.
I think it was paid just this week, Judge.
Well, there's been a warrant out for him. And he had to put him in NCIC. And he's been gone, and now he turns himself in Monday so he can come to court here on Thursday.
And you know, people don't realize that's not a trivial thing, putting somebody in NCIC. I think the state police has to spend 2 to 3 hours every time we put somebody in NCIC.
You know,
but I guess we're just kind of a throwaway.
Well, I'll tell you what I'm going to do. I'm going to take this under advisement here, and I'll let him out on the 19th.
Judge, can I tender to you a release packet, a mitigation packet from his significant other?
You can have it filed, yeah.
Okay, I'll do
Yeah,
that.
and I am mitigating it. I'm not gonna revoke him, and
I might subpoena her here for the 19th and see why she did waive it. I'm curious if there was any threats made or if she just
well,
decided.
let's
this was more
reschedule this
stressful.
on the 19th,
Thank
try
you.
to have her here, okay? And then
Okay,
you
thank
can-
you, Judge.
You can submit that then. Okay, thank you very much. Justin Gillespie. Justin Gillespie for sentencing. Commonwealth versus Justin Gillespie. Are you Justin Gillespie?
Yes, sir.
Good morning. You're on 25 CR 0049 for sentencing. Mr. Gillespie, were you born in 1985?
Yes, sir.
Last four digits, social security number 5237.
Yes, sir.
You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
As far as I can do.
Is there any reason why this gentleman should not be sentenced today?
Not that I'm aware of.
On pleading guilty, possession of controlled substance, first degree, second offense, he shall receive a sentence of 1 year to serve. The 1 year shall serve consecutively to Monroe County case 24 CR 0026. He agrees to have any all evidence destroyed. Court costs $165. He can start paying it $30 a month, 30 days after his release, okay?
Yes, Your Honor.
Thank you. Tony Graves. Commonwealth versus Tony Graves. For arraignment, 25 CR 0070, Commonwealth of Kentucky versus Tony Graves. You are Tony Graves?
Yes, sir.
Were you born in 1964?
Yes, sir.
Last four digits, social security number 7075.
Yes, sir.
Are you have an attorney?
Mr. Kevin Plant, whatever his name.
Public advocacy. Continue that appointment. You have the right to remain silent. Your attorney is here. The grand jury of Monroe County has returned an indictment charging you with possession of controlled substance first degree and possession of drug paraphernalia and operating a motor vehicle with headlight. Acknowledge the identity of your client, receive the indictment, waive formal reading and enter plea of not guilty, reserve all pretrial motions.
I do, Your Honor.
Sign a reciprocal discovery order, Mr. Graves, that requires the Commonwealth to provide your attorney with information to prepare for your defense. I'll schedule your negotiation day for the 6th of February and your next court date, February 19th.
Your Honor, if I could address bond.
Sure. Go ahead.
Your Honor, it appears that we had filed a 60-day motion in the underlying F case and that upon arraignment, he received a $5,000 cash bond, but then it converted to a $0 no bond. And so I've just asked this court to either convert it back.
You have to speak up just a little bit.
Your Honor, it's my understanding he has a no bond in this case. And so we would just ask this court to allow him to get a ROR or unsecured bond.
Mr. Stockton?
He had a $20,000 surety bond upon indictment, and then once pretrial called you, it looks like you said no bond.
Yeah.
Looks like all he has pending is the possession case. He served everything else out.
Okay. Well, I'll do a $20,000 clerk approved surety on it.
Yes, sir.
I'll give you a $20,000 clerk approved surety, Mr. Graves. You can have somebody come in and sign it, okay?
Thank you.
The 6th of February at 9 and the 19th of February.
Okay.
Jared Hale for sentencing. Are you Jared Hale?
Yes, sir.
Morning. We're here on 24 CR 0092 and 24 CR 0089 for sentencing. Were you born in 1984?
Yes, sir.
Last four digits, social security number 9494.
Yes, sir.
Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir, as far as I can tell.
Okay, is there any reason this gentleman should not be sentenced?
No, Your Honor.
Okay, upon the defendant's plea of guilty, indictment number 24 CR 0092 for burglary, third degree, 2 counts, he shall receive a sentence of 5 years on each count to run concurrently for 5 years. On indictment 24 CR 0092, the charge of theft and lawful taking of disposition 2 firearms, he shall receive a sentence of 5 years on each count to run concurrently for a total of 5 years. The 2 5-year sentences shall now run consecutively for a total of 10 years. Under indictment 24 CR 0089, a theft by lawful taking or disposition of livestock 10,000 or less, he shall receive a sentence of 5 years. The 10-year sentences on 89, the 5-year sentences on 89 shall run concurrently for a total of 10 years. Probated for 5 years supervised. The defendant shall have no contact with the victim or victim's immediate family.
And that's something I need to clarify, Your Honor.
Okay, go ahead.
If I could. I've been contacted, just to make it explicit, we've been contacted by the following people. His family members, Wesley Kyle Smith, Kaylee Marie Smith, Dwayne Hale, and Winston Hale, he's to have no contact with unless further order of the court. Also, Precision Engineering, he was indicted on a criminal trespass in that. And for some reason, I didn't put it in the plea because it was a violation. He needs to stay away from that business.
Yeah, well, that needs to be reduced to a judgment, okay?
Okay, I can give.
And let me talk about these firearms here. When they talk about firearms, no, I don't guess there was.
I thought there was firearms involved.
Can I say something, for him to be saying for me to stay away from my grandparents, Winston Hale, that's my grandpa. I don't know why I would be needing to be stay away from him, for one thing.
If they come in and say you can be around him, I don't mind. I've just gotten that information.
What he says that information has been provided, and if your grandparents want to come into the Commonwealth Attorney's office or County Attorney's office and ask that to be changed, he'll sign an agreed order to do that, okay?
All right, like I say, I don't.
He just heard one side of it. Okay, now you can get your grandparents to come in and tell the other side of it. We can correct that. I understand why someone wouldn't want to be kept away from their grandparents, even if you've had problems with them. And I'm not saying you have. There is always reconciliation. So you don't need to say anything else. You're in good shape right now, right? You just have them to come in and make an arrangement for that, sign a statement, and that can be removed, okay? Okay, thank you very much. Yeah. Gary Hall. Commonwealth versus Gary Hall. Are you Gary Hall?
Yes, Your Honor.
This is 25 CR 0069 and 23 CR 0040. Good morning, sir. Were you born in 1978?
Yep.
Last four digits, social security number 6975. You're here for the
Yes, sir.
arraignment on 69. I say for arraignment on 69. Let's see here. The grand jury of Monroe County has returned an indictment charging you with possession of controlled substance, first degree, third grade offense, possession of controlled substance not in the original container, and possession of drug paraphernalia. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor. However, we have worked out a deal on this case to go along with the revocation matter that was also scheduled for
A
today.
deal.
Yes, Your Honor, an offer.
Has the offer been accepted?
Yes, Your Honor.
So you have a plea?
Yes, Your Honor.
Okay, well, I'd rather hear about the plea than a deal. Is this a felony plea?
Yes, Your Honor.
Okay, a motion has been tendered that says you wish to enter a plea today. Is that correct, sir?
Yes, Your Honor.
Are you currently under the influence of drugs or alcohol?
No, Your Honor.
Is this plea freely and voluntarily given?
Yes, Your Honor.
Are you the same person that we just identified in 25 CR 0069 and 23 CR 0040?
Yes, sir.
Have you had plenty of time to discuss this matter with your attorney? And are you satisfied with your advice? Is your judgment, is your judgment impaired today in any way?
No, sir.
You have certain rights under the Kentucky and the United States Constitution. You realize you do not have to enter a guilty plea until I understand you know those rights. I can't accept it. So I'm going to go over them. At the end of that, I'll give you an opportunity to say if you understand what's going on. You have a right not to testify against yourself. No one can make you say anything. You have a right to speed trial by jury, right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you, a right to produce evidence, right to call witnesses in your favor, and have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. Your right to require the Commonwealth to prove beyond a reasonable doubt you're guilty charged against you. Understand that by entering this guilty plea today, you give up those rights. Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I will wait the pre-sentence investigation report from probation and parole. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have a right to withdraw your plea of guilty and proceed to trial. You understand that?
Yes, sir.
What is the Commonwealth? Mr. Judge is going to give the Commonwealth's recommendation. Listen very closely to this, if you will. Mr. Judge.
Thank you.
The Commonwealth recommends the following amendment and or dismissal without prejudice of following charges. First is dismiss possession of controlled substance not in original container and possession of drug paraphernalia, Class A misdemeanor. Upon a plea of guilty to possession of a controlled substance, first degree, third offense, methamphetamine, the defendant shall receive a sentence of 3 years probated for 5 years supervised. The defendant shall enter and complete the Monroe Specialty Court and shall remain incarcerated until the morning of orientation. The 3-year sentence shall run consecutively with Monroe indictment number 23 CR 00040 and Monroe indictment number 23 CR 00040. The defendant agrees to extend the probation for a period of 5 years supervised. The defendant shall receive credit for time served. The defendant agrees to have any and all evidence in the above style cases disposed of in a manner with the laws of the Commonwealth and the holding agency.
Sir, is that your understanding of the Commonwealth's recommendation?
Yes, Your Honor.
Okay, are you pleading guilty to the, because you committed acts charged in the amended indictment?
Yes, sir.
Doing so of your own free will?
Yes, sir.
Your constitutional rights that previously explained to you, is it still your desire to proceed, enter a plea and allow the court to fix your punishment within the range permitted by law?
Yes, Your Honor.
Understand that by entering this plea, any future convictions could be enhanced under persistent felony offender law. Do you understand that?
Yes, sir.
Okay. Is that your signature on there?
Yes, sir.
Okay. I will accept the plea to order pre-sentence investigation for scheduled sentencing for the 19th of February. Okay? Thank you very much.
Thank you.
Dixie Hart. Commonwealth versus Dixie Harter. Are you Dixie Harter?
Yes, sir.
Born in 1985.
Yes, sir.
Last 4 digits, social security number 0833.
Yes. Yes, sir.
You're on 24 CR 00105 and 24 CR 0088. For the purpose of arraignment, you have the right to remain silent. The grand jury of Monroe County has charged you with bail jumping in first degree in 00105 and being a persistent felony offender in 24 CR 00105. Who is your attorney?
I don't have one, Your Honor.
Okay, I'm gonna I'm gonna appoint public advocacy as to represent incarcerated defendant. You acknowledge Ms. Harder's identity, that you acknowledge her identity, she just
Yes,
mentioned,
sir.
she identified. Receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, sir.
I guess you'll need to get me ordered. I'm gonna go ahead, since she's incarcerated, you don't have enough proceeds or money to hire a lawyer, is that right?
No, sir.
Okay, well, they'll be over to meet with you and talk to you. Yeah,
Are we being appointed on the other cases as well, 24 CR 88?
well, that's a revocation.
No, it's, she was arraigned, I think what's happened, Your Honor, in 24 CR 88, she made a bond, I believe, or she was released. And she didn't show up for an arraignment, and that's when she was placed in NCIC and indicted for bail charge. So,
You are being appointed for both of them.
yes, sir. And I just asked that both cases be on for the docket next month along with the negotiation.
Both cases will be on negotiation for the 6th, and the next court appearance will be the 19th. Okay,
An arraignment needs to occur in that other case.
Yeah, she never was arraigned.
well, that's a Rainer. Give me the indictment, in the other case. We're also gonna return the indictment here, read the indictment for the date previously scheduled when you did not grace us with your presence. You charged with the grand jury charged with speeding, trafficking controlled substance, first degree, first offense, traffic controlled substance in third degree, possession of controlled substance in the third degree, possession of marijuana, being a persistent felony offender. You acknowledge receipt of that indictment. You previously acknowledged your identity, you waive formal reading arraignment, enter plea of not guilty.
Yes, Your Honor.
What I have her bond sit on?
No bond.
Continued no bond. Okay. Tiffany Hitson. Tiffany. Good morning, Tiffany. You say Hitson, is that, or is it Heitson? Hitton. There's no S in it, right?
No, there's an S in it. Son. It's son.
22 CR 0026. You're on a probation violation. Were you born in 1994? Last four digits, social security number 5920. Is that correct?
Yes, sir, I was.
What does the Commonwealth have to say in this case?
Your Honor, she has a 5-year sentence for receiving stolen property. She absconded in August of 25 when she was discharged from the Hope Haven, I believe, in Bowling Green on July.
I ain't never been out.
Hold on, Tiffany.
So whatever. And she was somewhere and she didn't appear, and she's been absconded since August of the last year.
Your Honor, Ms. Hitson's warrant has been pending since I believe mid last year. She was picked up on the warrant last month, but based on when she was picked up, I didn't realize she had been picked up until right before negotiation conference last month, so I did not get to meet with her beforehand. I was hoping we could pass her case until next month. That way I could discuss the circumstances with Mr. Stockton, see if there is any way to work this out.
What's the underlying charge?
Receiving stolen property. I think I called it, had some drug paraphernalia. It was a rental car. And we've had to put her in NCIC twice. I don't mind letting Miss Hill get prepared for the case, but I don't think my attitude's going to change about it.
Okay, February the 6th will be a negotiation day. You arrange for her to be transported here in February 19th, and there's a no bond on this also. Make sure. Okay. Your attorney will be over to talk to you. Thank you.
Thank you.
Yeah. Brian Hunter. Commonwealth versus Brian Hunter, 24 CR 004. Are you Brian Hunter?
Yes, sir.
Good morning. Year of birth 1992.
Yes, sir.
Last four digits of your social security number 3209. You're here on shock probation revocation. What does the Commonwealth have to say?
He has a 3-year sentence on possession of a controlled substance first. And we brought this motion because on December 26th of 2025, he allegedly assaulted Kayla Hunter.
Your Honor, we are going to stipulate to the fact that Mr. Hunter has acquired a new charge for the assault fourth. We would just ask for the court to take into consideration that he has not been convicted of that charge at this time and allow him to remain on supervision at least until there is a conviction or an acquittal on that charge. If he is convicted in the future, it is always possible for the Commonwealth to refile.
I think that that's the most hedged stipulation I've ever heard in my life. He's either going to stipulate or he's not. And if he's not going to stipulate, she's here. She doesn't want to testify, but she's prepared to. But if he wants to put her through that, we can have a hearing.
No, I'm fine with being, with the revocation. I'll take my time.
Okay. He stipulates, so we will revoke the shock probation. Okay. In the order. Thank you very much, sir. Mark Hunter. The victim's advocate can tell her that she can leave now, or somebody can tell her. Ma'am, you're excused. Are you Mark Hunter?
Yes, sir.
This is 19 CR 00114, 22 CR 0053, 25 CR 0032, and 25 CR 0079. The last charge is for an arraignment. Mr. Hunter, were you born in 1977?
Yes, sir.
Last four digits of social security number 8597.
Yes, sir.
You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with sexual abuse, first degree vulnerable victim. You understand what that charge is?
Yes, sir.
Okay. You acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, Your Honor.
Schedule this for negotiation day on the 6th. 6th of February, and the next court date on the 19th. I'm signing a reciprocal discovery order, sir. Require the Commonwealth to provide information to help you prepare for your defense. Okay.
All right, thank you.
Are you continuing all the other cases?
The cases all will be continued till that date, and all of them included in the negotiation.
Yes.
Commonwealth versus Timothy Jackson. Good morning. Are you Timothy Jackson?
Yes, sir.
Born in 1984.
Yes, sir.
Last four digits, social security number 9460. You're here
Yes,
today. Have you had opportunity to look at these two pre-sentence investigation reports done by probation and parole?
Yes, sir.
Well, they're substantially correct.
Yes, sir.
Okay, there are two of them, so I'm going to have to read them separately, but they'll be in the judgment. Upon a plea of guilty of possession of handgun by a convicted felon and persistent felony offender first degree, the defendant received 20 years to serve. The defendant understands that this agreement, he will serve 10 years before being eligible for parole. Upon a plea of guilty to fleeing and evading in 25 CR 0048, he shall receive 5 years. Upon plea of guilty failure of a non-owner or operator to maintain insurances, shall receive a fine of $500. The 5-year sentence Monroe Circuit Court fleeing of evading shall run concurrent with the 20-year sentence possession of handgun for a total of 20 years. Upon plea of guilty of assault, second defendant shall receive a sentence of 5 years in 0031. The 5-year sentence in 0031 and the 5-year sentence in Cumberland Circuit Court 25 CR 0060 shall run concurrent with a 20-year sentence in Monroe County for a total of 20 years to serve. Now, we also have Cumberland Circuit Court meeting here by agreement, is that correct?
Yes, sir.
Upon a plea of guilty to theft unlawful taking less than 10,000, you sentence to 5 years. 5 years shall run concurrently with Monroe Circuit Court case number 25 CR 0048 for 20 years. Is that correct? Finish to pay restitution to the victim. Now restitution will be determined by the court at a subsequent hearing.
Yeah, I don't know if Mr. Jackson's gonna agree or not, but we researched the pickup. And according to Kelly Blue Book, it was worth $5,100 if sold privately and $5,900 trade-in. I propose to put $5,500 in there. It's just a compromise.
Your Honor, I just spoke with Mr. Stockton about that this morning. I've not been able to discuss it with Mr. Jackson. If I could just have some time to discuss it with him, if we can reach an agreement on that, we can just submit an agreed order on it.
Okay, well, what I'm gonna do is I'm gonna enter an order for $5,500, subject to you being able to review it with your client and have a portion of that set aside.
Yes,
Okay. Okay, thank you very much. Jacob Keith. I'm waiving the court costs in that last case, waiving the court costs. Commonwealth versus Jacob Keith, 25 CR 0078. Are you Jacob Keith?
Yes, sir.
Good morning. This 25 CR 0078. Were you born in 1984?
Yes, sir.
Last 4 digits of your social security number are 4943.
Yes, sir.
Okay, you're here for the purpose of arraignment. You have an attorney here, Mr. Bell. You have a right to remain silent. The grand jury of Monroe County has returned an indictment charging you with sexual abuse first degree to a vulnerable victim. You understand what that charge is?
Yes, sir.
Okay. Mr. Bell, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, interplea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Set a negotiation date on this for February the 6th, next court date on February 19th. I'm signing the reciprocal discovery order, which requires the Commonwealth to provide your attorney certain information to help you prepare for your defense.
Yes, sir, Judge. Judge, if we may, I know that he's got a $10,000 cash bond. We're not asking to amend the bond as far as lowering it or anything, but we would pursuant to 431-535, asked that the court make that double property, which would be 10,000 cash or 20,000 property.
Well, I don't know anything about the case, so obviously, so you need to talk to the Commonwealth about an amended order or anything like that, unless you want a bond hearing.
Well, Judge, I mean, per statute, it's my position that you can make it with stock bonds or double property. We're not asking to lower or change the bond. We're just asking for a different way to make that bond, which is provided in the statutory language.
You don't think I can set a cash bond only? If I set a cash bond, you think that they can make any of them with property?
Well, Judge, if I say you can't, you would, and I'm not gonna do that, but I mean, I know you can, but I'm just saying statutorily under.
Well, I don't want to violate the statute. Are you telling me that statute prohibits me from doing a cash bond?
Well, it's my position that it doesn't prohibit a cash, but it prohibits that being cash only. There has to be other means.
So you're saying that it would prohibit me from doing a cash only bond?
If it's requested that it be made double the property or stocks,
well,
things of that nature.
I'm not aware of that.
I've had circuit judges to interpret that way in the past.
Yeah. Well, this one hadn't interpreted, but I'm still educable. If you can convince me if you convince me that's what the statute says, I wouldn't intentionally not follow the statute.
I know you wouldn't, Judge. It just says any person who has been permitted to execute a bail bond may secure such bond by deposit of cash or stocks and bonds having an unencumbered market value not less than the amount of the bail bond, or by real estate with unencumbered equity at least double the amount of the bail bond. Then it just goes on through that. So,
but yeah,
it doesn't say shall, but it does say may. So that would be the stretch.
That's what I always understood. So it's not same as a clerk approved surety is it's not a surety bond.
But we're wanting double the property.
I understand that.
Yes, sir.
But it's not a surety bond, so it would be, you're asking a property. The other thing would be personal property, right? Read that statute again, read it again.
It only bails, bonds, or, under 431-535, it provides any person who has been permitted to execute a bail bond, which he has with the $10,000, may secure such bond by deposit of cash or stocks and bonds having an unencumbered market value not less than the amount of the bail bond, or by real estate with an unencumbered equity at least double the amount of the bail bond.
Yeah.
Then that's all we're asking for.
You don't have stocks and bonds that you want to put up?
No, sir. I just got some property I'd like to be able to him to put up, which is 20,000 property, which is equivalent to.
Unencumbered.
Yes, sir.
You have any objection to that?
Well, I would ask, I didn't realize, going back looking through his criminal history, that I may have made a mistake in 2010 when I amended a previous sexual abuse down to an assault fourth. So this is not his first time he's been indicted on sexual abuse. So if he is let out on that, I would ask for an ankle monitor or whatever, some stringent conditions.
We would agree to anything like that, Judge. The only thing I asked is be able to work. He's got a business and he's got a very good job that he's making good money at. He just don't want to lose it. And he's in jeopardy of losing that. As long as he can work, we don't care if he stays at home all the time.
What are the allegations, sir?
I want to read it, so I'll make sure I'm correct. He allegedly walked into a room, shook a couch, woke up an 11-year-old girl, counted down from 3, 2, 1, told her to open her eyes, and he was masturbating in front of her. Now, that's the allegations with the child baby. And Mr. Bell will need to tender an agreed order so he can watch the advocacy center tape.
I don't know anything about the case, Judge, whatsoever. I went and seen my client at the jail last night, talked to him, and but whatever the charges or allegations at this time, he's presumed innocent until proven guilty. He's been given.
Everybody that comes in my court is presumed innocent, and a lot of them are held on no bond because of aberrant behavior or certainty behavior. That's why we have bond hearings.
But we've been given a 10,000 cash, and we're not.
I understand that. Now you give me, I'm having no more about it than I did when I set the $10,000 cash, and I might not have set the 10,000 if I'd known so much. See, because I can't call a Commonwealth attorney and ask them about it. That's an ex parte communication. Nor can I call you and talk to you about it.
Well,
So
you
now that
call
I
me,
know the nature of this charge and what the allegations are, I want some additional protective measures in the bond. Stay away from the victim. Is the victim a member of his household? I don't know.
I don't know if he doesn't have any minor children. I wouldn't expect him to be around any minor children under those circumstances.
Well, I don't know what this person, whose household it was, whether we should have him vacate the premises where he is. I mean, I just want y'all to reach an agreement on this, and I will, I'll take a look at letting him secure it with property or something like that. But Mr. Stockton, I want you to talk to defense counsel, make sure that we protect any potential victim, or whether or not it actually happened, the fact that the allegation was made sometimes puts somebody in danger. So I will look at an agreed order if you'll look at that, okay?
Yes, sir, Judge.
Thank you very much. Courtney Mabry. Okay.
No, I'm just saying we're over here.
Commonwealth versus Courtney Mabry.
Yes, sir.
23 CR 0020. Are you Courtney Mabry?
Yes, sir.
Hey. Good morning. We're on a probation revocation. What do you have to say, Mr. Stockton?
Miss Mabry is a Tennessee resident, I believe. She wanted to live in Tennessee, and rather than being up here supervised, so she was placed on unsupervised visitation, not to be back.
Supervision.
So as long as she stayed in Tennessee, she's gonna be unsupervised. And then she comes back to Kentucky and gets charged with a DUI. And I can't have the hearing today because the state trooper that arrested her is on military duty and won't be available at the 28th.
Okay, well, let's schedule this for the 19th.
Your Honor, if I may, we may be willing to stipulate to the violations to be able to have the hearing today. I just have not asked Miss Mabry. I've met with
I don't
her.
really think she wants to stipulate to this because it's not, if she's come back up here and has a DUI, it's not gonna end well for her. But if she wants to go ahead and get it out of the way, that's okay. She wants to stipulate to the DUI, I can take care of that. I just revoke her probation.
No, Your Honor, let's pass it to.
I think that's probably what you want to do, okay? So let's do it on February the 19th. Can your witness be here on February
I
19th?
believe he can. We'll have to go back.
Okay, thank you. Let's go back to Michael Ludwig. Your turn, Michael Ludwig. For arraignment. 25 CR 0067. Are you Michael Ludwig?
Yes, Your Honor.
Good morning.
Good morning.
We are here on 25 CR 0067 for arraignment. You have I'm on point public advocacy to represent you. Did they represent you before? Or did you have a do what?
I really don't know.
Okay. Well, I'm gonna let you fill out an affidavit. I'm gonna put a public defender on you right now. The grand jury of Monroe County's returned an indictment charging you with failure to comply with sexual offender registry first degree. You understand that charge?
Yes, Your Honor.
Okay, I'm not asking you what he did or not. I'm just asking you to understand the charge. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
Okay. Okay, I'm gonna set this for negotiation on 6th of February. And on February the 19th will be the next court appearance.
Yes, Your Honor.
Stephen Stewart for arraignment.
Judge, I had received yesterday, we did not enter it, but an agreed order continuing the arraignment.
Realize.
Yeah, you're on the record.
Oh, well, I don't really want to say anything to the record.
Okay, do you want to continue it?
I do want to continue it one time.
Okay, we'll continue arraignment. Do you want him there for negotiation day? You want him there for negotiation day, Mr. Stock?
But no, I just want him to turn here next court day.
On 19th?
Yes.
Okay, this will be continued to agreement between the parties for inconvenience. Christopher Stillwell. Christopher Stillwell. Are you Christopher Stillwell?
Yes, sir.
Good morning. This is 24 CR 0012. We're here on a probation revocation. You're represented by Mr. Bell. You were born in 1975 and the last four digits, social security number 6497.
Yes, sir.
Okay, what does the Commonwealth have to say?
Your Honor, Mr. Stillwell has a 10-year sentence for trafficking. And he has this probation violation. I think we need to have a hearing. I need Officer Wesley Bray on.
Okay, let me take just a break.
Okay.
2-minute break here. Let's go off the record. Hello? All right. Walking off the picture, take a break. How are you doing?
Absolutely.
Maybe.
Maybe. Maybe you did. They aren't saying. Which you have about. So they get you today.
Okay.
I want to be having on step back.
Okay.
So I don't want you to do that.
Your team's coming yesterday. She came on the business.
Yes, it was like the afternoon, so they.
It's still checking.
Yeah, there's a chance, but she goes, you want me having on step back, so they'll already have to.
Okay.
Yes. Well, you taking time then? No, no, are you trying to, I'm just, you going to revoke it? Oh, is that what this is? I didn't know.
Yeah, he tries to vote everybody that comes on the road.
I say nothing. That makes stay out of it. Yeah, that is.
Yeah.
He reading has to. I let it work yesterday and I thought, man, that feels like Thursday. And
I mean,
I wanted it to be Friday so bad.
I already know. I'm just trying to get some treatment.
You brought that up to your turn.
Yeah, you know, I heard on bail, he told yesterday, he trying to hear nothing, you know what I mean? All he wants to do is send him up out of prison. But I'm gonna ask the judge straight up, I almost died in jail. I'm gonna break.
Squeaky wheel gets the grease, man. That's all I've ever been told.
Yeah, yeah. I'm shooting straight. Let me speak. I done everything I'm supposed to, you know what I mean? I just messed up and I was in there, I just tried to road this. Yeah.
Mistakes happen.
Yeah. I mean, I think it punched me for the steal. Everybody is like, y'all give me 10 years for it. If I made all my fines, I had a job.
Yeah, I think it's all the court going with.
Stay home, pitch up the jet and stop, leave that.
Yeah.
Like you said, he never gives up on it. Yeah, and he don't. They don't. Sometimes I guess that's chance for how long they live in this world. Ask what you need to do. But I can't give you any advice.
And I don't want to do it.
Yeah, oh, well, that's good. First step is accepting and knowing that you did. But it's like I said, it's with the street. Yeah, I think they don't. I would just.
Great numbers. Mom can make it till I do get out.
What's wrong with it?
She's just she got a infection. Food getting into her head, it's an infection.
They give her like going septic, stuff like that.
2 weeks to live, you know what I mean? I mean, going through it like that.
No, I don't think, I wish that on it, but that's the hardest thing ever.
Yeah. And then you got this sorry ass prosecutor on the prosecute to the fullest. But I did good, man. I paid off all my shit, all my fines. Every day, Ray can't say nothing bad about me, nothing. Except for that week.
Is that the thing?
Yeah. It's just a bad choice.
So they listen, you know, she's thinking about it.
I already know. I regret it. I know it would never happen again.
Fair enough.
I get to this.
Maybe what they give you a chance to.
I hope it does. I would do it right. Think very hard about it.
I had a second, or a circuit like this for a long time. Little while. Usually they track, I don't know why they didn't transport it, but I used to take it, but
It's getting stoned a bit.
it's not right now, yeah. Yeah,
I was supposed to get.
I have no idea. Try not to look at it, let's drive on my way.
Yeah, I was seeing it in.
Some people hate it, I love going out. I love it, love driving it, it's fun.
It's kind of enough, so I'd say.
Yeah.
Speak.
Oh, yeah, I was sticking outside when I went out there looking at my kid, I was 12 years old.
Oh, so you're running. Way outside too.
No, not so much wind, it's just, it rained for the rain and then got rid of it.
I know the weather's been changing.
I still feel like everybody's so sick.
Yeah, it is. I think it's gonna stay cold this time.
Oh, yeah, yeah,
Much more warm weather.
yeah. It usually happens like February. It would be so bad if the wind wouldn't blow it so hard.
Yeah, I know it's, and one with that. It's past 45 years. We have one that covers. Like it's usually covered. Some kind of extra frost in the air, it's like extra crisp. I just love it. Everyone would come to this festival.
Take it day by day.
Okay, God makes, I think it's act from God.
Take it day by day.
Let me go home today. I got a deal on yours. He just told me that they want to give me 5 years, probably. 5 years, 260 days to serve, and the remaining 3 years of probation.
Like, have you scraped out there?
Yeah.
Good.
Yeah, I should be released today.
Yeah, it seems you've done hopefully.
Yes, so.
Like I said, they put y'all in pretty late, so she won't be having on standby in case it's sad to see.
Made it learn agility today.
So it is, though.
Yeah.
On Fridays we had to do.
Yeah, it's pretty good.
I love to fish.
It looks like to fish, but I think it's good, you know.
Well, I don't.
My business big, but they like chicken.
I have no idea. It's good though. That's chicken salad last night. She done had no wrong time. My mom made it.
They have grapes in it.
It did. You can't have chicken salad and grapes.
I know it's good like that. I understand you.
Oh, yeah, we get, it's not chicken salad like camels.
Yeah.
I guess that's what they're, we call it cat food. That's what everybody's. Where we go. That's good.
What'd you do for holidays?
Nothing, I was sick.
What'd you?
Yeah, the whole fucking time. Had the flu 2 days before Christmas, had that all the way to Christmas, and I had rock fights all over the beach.
Yes.
I laid home and died in bed for about 2 weeks.
Yeah, we was to breaking this. You didn't work Christmas, were you sick?
Yeah, I was like, I didn't work, I couldn't get out of bed.
This girl that came in from, she's gonna do the weekends. She said she's had pneumonia. Yeah, but you're right, it's like it's from the weather.
Yeah, flu. Flu's real bad right now.
What you say? I don't know.
There's a little boy died long ago.
Really?
With flu.
It's here. And the KCPCs, they told me, we get the information out. Mother been like, he's sleeping in a real bed. It's oil from a meeting that said,
Oh, yeah.
it ain't nothing like that.
Nothing like that.
No, it's worse than two.
A guy didn't been like this, so.
Yeah, why does it say 60 days?
Well, I
Why don't we treat him?
I have no idea what I said.
Yeah,
I thought it was pretty wild last time.
me too. I'm just glad I had that with me.
Yeah.
See, like, to the point right now, I've been done.
Yeah, it's like the back of everything now.
Yeah. Yeah, I'm ready to be back here to the jail. So, they give you 50 pieces of the gun, they give 3 balls, 3 first cans. And then they give you a long john pants, long john shirt. They give you 3 pairs of tan pants, 3 tan shirts, and they give you a jacket, gloves, and sunglasses.
What's all those?
No, I don't know, I guess it's just the sun and maybe studies.
Give me 2 minutes.
Yeah, all we wear, oh yeah, they give you to me too. It's cold, it's cold. It's real cold, it's all it is. I did have heat though, turn the heat on. Yeah, last a month. They give you 2 trunks, 2 blankets to cover up when it's at home. Yeah, I'm glad to be back here from the gym.
Oh, yeah.
Candace told me that they got me home today, so I sure got out.
That's just 2 minutes.
So you get your tickets somewhere?
No, I'm not doing it. Very great, it's kind of hard, by the time to do it.
Yeah.
But it's 24 now. But you know, like, as soon as they take one thing off your plate, put another one on.
Yeah. Was you the only one sick? Your family get sick too?
I got sick and then I think my grandparents got sick like the week after. My mom's. I get sick every year. Like Christmas time. So if anything had come, maybe sick. I'll go all year, not be sick at all. I think just about Christmas time of the year, I get something.
Not doing to me, that's the important thing. I've prosecuted all my cousins.
Okay, I guess we have Christopher Stillwell, is that correct?
Sir.
Yeah. 24 CR 0012. Are you Christopher? We're still got Christopher Stillwell here. What we got going on?
Your Honor, he has a 10-year sentence for trafficking. He was given an alternative sentence and then probated. And then on 11/12/2025, he attempted to, I guess, fake a drug test by using an artificial device. And I've got Mr. Bray here to testify.
And Mr. Bell, what do you have to say about this?
Judge, I've spoke to my client. I mean, in essence, we've seen the report and, I think the question's more not whether he was dirty for his test and tried to use the Whizzinator. It's just our position's more of what should happen to him. It's what
So you
we're,
stipulate to the Whizzinator?
yes, sir, we do.
I just want to apologize, Your Honor. I made a mistake, you know what I mean?
Hey, thank you for that. Thank you for apologizing. You did make a mistake. What kind of other thing do we have?
Well, this is the problem I've got with the case. One is the subterfuge used about the testing process, because we don't know if he's been dirty or how long he's been dirty, how long he's done this. And two, initially, I think Mr. Bell represented him before he ever entered a plea. I gave him a great break. He had 14 grams of meth with him, and he got 10 years in alternative sentence, and something didn't click. I don't know why he would do this, but according to Mr. Bailey.
I remember it was,
yeah. And so that's the reason I'm not willing to give him another break. He got a tremendous break at the plea, and then he does this. So it goes to the integrity of the system when people attempt to alter tests and this type of what.
Your Honor, can I speak?
oh, wait just a second. Your attorney can decide if he's going to call you or not.
Your Honor, I can tell the court why, because he's an addict And when he did get that sentence and got the alternative sentence, he didn't get the tools that he needs to be able to address the disease that he's got, which
That's
is.
because you got him too good of a deal.
Well, part of it, he got himself, to be candid with you, Judge. Him and Mr. Stockton, I believe, spoke and, you know, I understand all that, Judge, but I mean, I won't go into my own past.
Well, I'm not, you know,
but I
let me
do
ask
understand.
You know, you weren't there with him when he falsified these things.
I
So
would
what do you
just-
suggest?
Well, Judge, I've got a letter here that I'd like to
What do
present.
you suggest?
I suggest we've got him a bed at the Mark Center for 6 months in treatment at the Mark Center, which I think is one of the best facilities in this whole area. We've got the bed letter here. They've been holding it for us since late December, and we can get him in it immediately. I would ask that the court and the alternative to
Well,
revoke.
one of the problems that bothered me in the beginning of this thing was the quantity that was involved. It was on the edge of a lot of people.
I wasn't going to give in until Mr. Stillwell, I can remember he approached me in court and was telling me about his job and how he straightened up and he had a good job and everything. And I did, I gave him a break.
And he told the truth, Judge. He relapsed. It happens. And I mean, he's still working 2 jobs. He's got a guy here that he trims trees on the weekends. And then I've got a letter from Falcon Logistics LLC in Bowling Green. Both of these state what a hard worker he is and what a good job he does for them. He's not somebody that's out here trying to get a handout.
Well, you read the statute to me earlier today on something else. The statute doesn't say that people who work hard are not subject to following the laws of drug use and stuff in the Commonwealth of Kentucky. They're under the same thing. I'm glad he is working.
I agree.
But if he goes in this long-term treatment situation, he's probably going to lose his job too, because he'll be in that long-term treatment. Do they have work release there? What are you saying?
After the first initial 30 days, they put you on a work release situation.
Where's
So-
this place located?
In Bowling Green, Kentucky.
Okay, well, what I'm gonna do, how long's he been in jail this time?
I'm not certain, Judge.
How-
How long you been in jail, Chris?
Over 60 days.
You moved in on 11/5/25.
11/5/25.
Okay.
11/12/25 is when.
If I revoke his probation, he would be subject, still get shock probation, couldn't
After 30 days.
he? Okay.
The only issue that I would bring up with the court on that, Judge, when you revoke somebody on being, having a dirty test, it's just punitive toward them, and I just don't.
I'm not revoking him for having a dirty test. I'm revoking him for trying to corrupt the system and to try to sneak in and do something patently dishonest. And, you know, I would have more sympathy for someone who had a dirty test than someone that tries to bring a false statement and make a mockery in it. And I just can't overlook that. I just cannot.
He did admit it.
Well, hell, yeah, if you got caught, a lot of people, I mean, you get caught and it's laying out there and you got the, you know, the tube or whatever they call them, the P locator or whatever it is. I don't know what it's called, but I'm going to revoke him and I will take a look at shock probation with those sort of things that you're talking about after 60 days from today. So schedule him and we'll take a look at it then.
Yes, sir, Judge.
I just cannot allow people to come in and fake these tests and treat them any differently because they're articulate or work or whatever. They can't do it. They just can't do it. Okay, thank you very much.
I'll be to see you, Chris.
Tamara Stamper. We have a competency hearing.
Yes, Judge.
Hello. Good morning, Ms. Stamper. If it's still morning, you're the last one I say good morning to, okay?
I'm glad to be able to back on the donkey. I didn't thought I was going to wait until next month.
25 CR 0010. What does the Commonwealth have to say?
She's on for a motion for competency hearing. I spoke with Ms. Hill. My understanding is that she's supposed to stipulate competency. After reading the report, I sent Ms. Hill an offer. I don't know if she's accepting that or not.
Your Honor, I have not been able to talk to Ms. Stamper about the offer as of yet.
It was scheduled for February 19th.
I was actually going to ask Your Honor if we could schedule her for next week on the Cumberland docket.
I have no objection to that. Okay, we're gonna advance you to come to Cumberland County. You'll have to do a transport order.
Yes, sure.
Get her on Cumberland Circuit Court, and you don't need a negotiation day or anything before then. Okay, we'll see you in Cumberland County next week.
All right, thank you so much, Judge. I appreciate you.
Yeah, thank you.
Cloud.
McLeod, Commonwealth versus McLeod. Kenneth McLeod.
Yes, sir.
Yeah, are you Kenneth McLeod?
Yes, sir.
25 CR 00066, Commonwealth versus Kenneth McLeod. This is, you born in 1991, last four digits, social security number 7904.
No, it's 01. It should be 7901.
7901, okay, I'll correct that. I'm gonna appoint public advocate, the public defender represented you before, is that right?
Yes, sir.
Yeah.
It was Kevin Parent.
Okay, well, I'll go ahead and continue that. The grand jury of Monroe County has returned an indictment charging you with failure to comply with sex offender registry second offense. You understand what that charge is?
Yes, sir.
Okay. Counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Okay, I'm gonna sign a reciprocal discovery agreement here. Mr. McLeod, they'll be giving you information. Your attorney will be over. We have a negotiation day on February the 6th. We'll do a transport order, get you over there, and your next court date's on February 19th. Thank you very much. Y'all have anybody over there at the jail at Barron County that needs to talk to us? Mr. McLeod? Okay, well, y'all are excused. Thank you very much.
Thank you so much. Have a good day, Your Honor. See you.
Yeah. Is there anything else to come up? Show cause docket. We do it pretty
Can we
quick.
be excused, Your Honor?
Absolutely. Thank you for your cooperation.
Thank you.
Commonwealth versus Joseph Martis. Only behind $30. He can purge himself by paying $30. Rehab. Let's pass over that then. Pass over that. Let's put him out to about March the 12th. Take a look at it then. Matthew Prophet. How far behind is he?
You made a payment December 22nd.
$40. Supposed to be paying $100. Issue a bench warrant, purge himself by paying $100. Does that conclude the show cause docket? We're finished till 1 o'clock, is that right? Okay, we're in recess till 1 o'clock. Thank you. Child support docket. Caps versus caps.
Continue to March 12th, please, Your Honor. Oh,
You, Mr.
no,
Caps?
this is our motion to intervene. I'm sorry.
Okay. He can be excused. The county attorney's office is just intervening in the case so they can protect, I guess, the government. Is that right?
Yes.
Okay, thank you for being here today. Yeah. Crawford versus Crawford.
The rest of the docket is continued to March.
And we'll just call down to
Yeah.
the thing. Russell versus Curtis.
March 12th, please.
Fox versus Fox.
Continue to March 12th. He has an arrears of $3,595.
Yeah, y'all willing to give him a break of some sort here? We get him off the docket. Give him a discount.
$50 a month?
Graves versus Graves.
March 12th, please.
Turner versus Guffey.
March 12th.
Hassett versus Hassett.
March 12th, please, Your Honor.
Taylor versus Houses.
March 12th, please, Your Honor.
Hudson versus Hudson.
March 12th, please, Your Honor.
Jimenez versus Jimenez.
March 12th.
Just took me 10 years to get that name right.
10 more will have the first name.
Yeah, you might have it. I won't. Dye versus Jones.
March 12th, please, Your Honor.
Okay. Jones versus Jones.
Also March 12th, please.
Commonwealth versus Moore.
March the 12th, please.
Page versus Page.
March the 12th, please.
Pennington versus Pennington.
March the 12th.
Rich versus Rich.
March 12th, please.
And Smith versus Smith.
Also March the 12th.
Okay, thank you very much. Is the civil docket set for one here? That's good. Beatty versus Broom.
Represent Miss Beatty, and that's our motion for default.
Is that her coming up here?
Yes.
Okay, but it wasn't an answer file. Are there children involved? Property to be decided? What?
No property, one child.
Does she know where he is or?
No, he was incarcerated for a while. We listed the last address we knew him to be at, and we've had no contact with him.
And he's properly before the court been served?
Yes.
Is she going to ask to go by the child support schedule, minimum wage, or what are you doing on the child support?
She's not seeking any at this time.
Well,
unless you've changed your mind.
I mean, I really don't think it's fair to the citizens of the Commonwealth of Kentucky not to file thing. But, why don't you submit me an order and make a fine on child support at minimum, okay?
Of course.
And we'll sign it. Thank you very much.
Thank you.
Vanderbilt Mortgage versus Creek.
Judge Michael Kane here for the plaintiff. That's a motion to set aside the judgment previously entered and dismiss the case. The parties have worked it out.
Okay, submit it and we'll be glad to sign that, okay?
All right, thank you, Judge.
Thank you. Lakeview Loan Services LLC versus Jessica May.
Good afternoon, Your Honor. Jeff Helms representing the plaintiff. That's my motion for judgment and order of sale.
Okay. Let me find that for me there for a second. Is that number what?
Wait, or three.
3. Okay, excuse me. Is this a credit card thing?
No, this is a mortgage foreclosure, Your Honor.
Morgan, I saw that, the bank there. Okay, well, we'll go ahead and enter. Appears to
Thank
be
you,
an order.
Judge.
Okay, thank you very much. Have a blessed day.
You just,
Yeah. Burks versus Poland.
Your Honor, this is my motion on behalf of David Burks to set a hearing. There's some issues the parties just can't agree on.
Is Mr. Burks here?
He is, yes.
Okay, what kind of issues do you have here that you can't decide?
Judge, it's a timeshare. My client's job has changed since the last time the parties entered in agreed order.
She's not, Judge. His motion was just a motion asking for a hearing date, so I told her she didn't have to take off work for that.
She didn't have to be, but you know, we could maybe get things resolved.
Well, and I'll talk to Mr. Carter. I know he doesn't specify in his motion all the details of what it is he's wanting to modify.
Why don't you, have you got specificity on what you want modified?
I do, Your Honor. I mean, I can get him with Ms. Coleman or ever.
Why don't you give Ms. Coleman? I just don't really like to tie up hearing dates until I know what the issues are. I can give you one quickly. We don't have to wait for rule day here. It won't delay what you're doing. You to try to narrow it down. I might be able to hear it in Berks, or I might be, it depends on how many witnesses that we have, or I might calculate a day to come over here, either one. But until I know the breadth of the disagreement, I won't know how to schedule it. So.
Well, the gist of it is, Judge, that they've been operating under an equal timeshare for the most part, but the agreed order that's previously entered doesn't reflect that. And due to that, if she wants to change the schedule at the last minute, there's nothing we can do about it. So that's the gist of the case. But
obviously you agree with that.
Sure.
So it's gonna be easy, right?
I mean, there's other things, but I think that.
Well, those other things are a killer.
If we had hammered
I
out.
don't think it's the day-to-day schedule that they're, either of them are in
Okay, well,
disagreement
let's
on.
do a specificity serve on her, let's say within five days.
Okay.
You know, maybe a Wednesday next week, that'll get Wednesday with specificity. And then y'all talk to each other about it, and, you know, we might be able to even Zoom some stuff on it. Sounds like it's not the thing where there's gonna be a lot of exhibits or anything in. Okay, we'll move it along.
Thanks, Judge.
Okay, thank y'all very much. Gerald's versus Scott.
I don't. I was gonna say, I don't see her on, is she on Zoom?
Not sure where Holly is.
She's the one that noticed.
You think there might have been some confusion about which one of these cases?
That's my confusion.
As I say, she noticed it to me
I
last
called
week.
about it.
And she said that wasn't her case.
Yeah, that's right. I remember that.
She's filed a motion for this case.
Yeah.
Yeah. Well, let me see if I can get a hold of her. Are you on the way to Tompkinsville? Okay. Okay. Okay, we've got your case called. Just come on up. Bye. She's pulling it out front. Why don't we just pass over so you get a chance to talk to her just for a second, okay? One Main Financial Group versus Raleigh Shoptaw.
Yes, Judge Julie Gordon here on behalf of the plaintiff. It's on today for a motion for judgment on the pleadings.
You have your camera on?
It's not not only is the camera not working, my picture isn't up. I'm not sure what's going on with it. Let me see if I can switch something over here. Because usually if the camera doesn't pop up, my picture pops up on there.
Well,
I can switch over to my phone if you just want to be able to see me.
One Main Financial Group LLC versus Raleigh Shop. What kind of case did this originate as? Was this a credit card case or what was it?
I believe so, yes.
Okay, well, we double check service on that. Well, let me double check service in the file, okay?
Okay, and we did receive a pro se answer that was filed, but it doesn't raise any, there's no defense to they admit that there was a debt and admit that it was owed. They just go into some hardships that they're having.
Yeah.
And if it helps, I show
I'm reading the.
11/25.
Wait a second. I'm reading this response now. Okay, well, the attorney's fees do not appear to be excessive at all. So I'll go ahead and sign it. In the response, it talks about the rudeness of the employees. I mean, is there someone that they might talk to set up payments on this thing or?
Yes, I do have that information. I'm just local counsel, but I do have contact information. I don't know if you want to,
Well,
add
go
that in the
ahead.
file
I'm
somewhere.
gonna sign the judgment. And you tell them that the judge was concerned about the fact that this individual had claimed that they had tried to make these payments, but they were told they couldn't make payments. It appears like the thing where it'd be better to set up payments than to get somebody to go to bankruptcy court, but that's not my thing. Well, thank you for appearing.
Agreed.
You have a good day.
Okay.
Bye-bye.
Thank you, Judge.
Yeah, Dyson versus Osberg.
Good afternoon, Your Honor. I'm Amy Morketter from the law offices of Philip Dyson, making a special appearance for Mr. Dyson today.
Okay. What do we have here?
Judge, they're due some discovery from me, and as I disclosed in chambers, due to health complications, I've not been able to.
Yeah, what do you need from
It's interrogatories and then set up a deposition for my.
from another case Mr. Stevens has been involved in today? I am aware of some health problems and issues that he had. Mr. Stevens, what kind of time you think you're going to need?
I've met with my client. We just have to type everything up and have her come back and
Maybe
sign it.
20 days from today?
Oh, yeah, that's no problem.
I'm going to enter an order that it's excusable what he's done, and he shall be in compliance in 20 days. And if he's not, that gives you a chance to come back up here on February 19th for an order directing him to do that. Okay?
Okay, thank you very much, Your Honor. What time is that on February 19th?
Be at 1 o'clock.
1 o'clock.
Hopefully it won't be necessary, but If it is necessary, it'd be 1 o'clock, okay?
All righty. Thank you so much.
Thank you very much. That concludes the civil docket. Oh, yeah, Holly. Did you go back and get Miss Coleman and tell we're ready to pick that up? Where she is? Here it is. Okay, Miles Gerald versus Bailey Scott. Yeah, this is your motion to compel?
No, Judge, this is Ms. Coleman's motion to compel.
Okay, what we have here?
Yeah, I think that this was initially noticed by Ms. Perigin on just to review
Yeah,
the schedule, but we had also filed a motion to compel regarding the sharing the cost of the daycare expense for the child. I think I spelled it out pretty clearly. After 6 weeks after she gave birth, this last time, which was August 1st, she was supposed to be paying every other week the daycare. She's not paid any. And he has had this child almost 100% of the time, so he's bearing 100% of this child's expenses. So we're just asking that she start making those payments every other week to the daycare like she's supposed to, and we would also like to be reimbursed for the amounts that she did not pay.
how much is that?
It's in my order. Looks like total cost $2,040, and hers would be half of that. So $1,020 is what her half is
Judge,
up to today.
Our position is they seem to be picking and choosing what parts of the original agreement they would like to go by. Again, he has been 100% in Mr. Gerald's care. We're just now getting back to visitation with Ms. Scott, with the mother. So we would ask that we're not held responsible to pay this. Additionally, the child has turned 3 and is eligible for preschool, which is a zero cost to any of these parties to move him to an educational setting versus daycare.
He's already enrolled.
Wait,
He, as I say, he cannot start until August, so he has to stay in daycare till the school year starts. Just because custody was removed by a judge doesn't mean you don't still have to support a child. And I mean, all she's supposed to have to pay is half of the daycare cost, and she did not do any of that. So I would argue that she's not having to pay day-to-day
But she didn't
food.
file a motion to be excused from that. So
Judge,
the
not at this time.
the order is in place.
That is correct, Judge. At this time, she has only recently returned to work as of Tuesday. She has not worked since having her last minor
Well, we can
child.
set up some payments on the thing. What, the arrears would be approximately $1,000, something like that.
That was 1,020. I wanna
Yes.
say.
Yeah, what's the child support like in this case?
There's no child support, Judge. And he has not asked for child support, even though he's had sole custody for.
Well, we're fixing to start anew here.
So, yeah, and I mean, he's fine
It's
with that.
gonna
Like I
go
said, the.
On these 50-50 situations, let's say she gets back to 50-50. You need to wait just a second, calm down, okay? Okay, thank you. If it goes to 50-50, what will be the child support situation then?
Their agreement that originally was in place with that, it was that they were not going to do child support, neither was going to pay the other child support. They were just gonna split the expenses 50-50. That was the agreement.
And since we had not had the child for 50-50, Ms. Scott was also not working. She was unable to pay any of that or have visitation with her child.
Well, those are issues that I can't go back and redo that.
Understand, Judge.
So what we'll do is we'll allow her to pay $40 a month for the arrearage of $1,020 or something like that. That's something that should be manageable without changing things.
Pay that too.
Pay it into the clerk's office. Okay, pay it into the clerk's office. Now, is it still your position that you don't, I haven't had a 50-50 where things weren't agreed to. And they agreed to 50-50, but it seems like some things have changed or something. So what do you have to do to reopen? I mean, how much money does he make compared to what she makes?
I don't have any idea.
Well, at some juncture, you might want to revisit the child support thing. If there's a big disparity here, and we take a look at it, But that'll be my ruling, that she get a judgment for $1,020 or whatever it is, and she paid $40 a month.
Okay.
And also that she is going to, starting today, start making her payments as ordered to the daycare.
How much is it a week?
It's $120 a week, and they're supposed to just take turnabout every other week, making the payment directly to the daycare. That's how it was written.
Miss Scott will not receive her first check.
Till next Friday,
How much you receive a week? What do you-
$20 an hour.
Okay, well, let's just wait 2 weeks before we start doing that. You add another 120 to the arrearage, okay? And that will give her a couple weeks, start getting on her feet, okay?
Thank you, Judge.
Yep.
And then as far as the review portion, we would like to review the expansion of the time sharing. And currently, Miss Scott is being drug tested every Monday before her visits by the cabinet. And Judge, just for the sake of her credibility, we would ask to switch it up and let her be drug tested anytime, not just Monday, because we don't want the other side to say that she's cheating the system or anything
You know,
like
you're
that.
creating a situation that we don't need to go into, you know.
Well, Judge, we're here to expand our time and show
Okay,
that
well,
she's
what's the
made
time
substantial
now? What's the
improvements.
time now?
This last month we expanded, so she had overnights on Mondays, and then she had Wednesdays for, I think, 4 hours. So I mean, I think our suggestion would be that we start making those Wednesdays an overnight as well, and maybe start giving her, a full day visit on every other Saturday or something.
Why don't you send a proposal to opposing counsel to, how old's the child now?
2.5 or 3, I'm sorry.
Okay, well, let's do, have a goal that within a year, increasing the community within a year, we'll have full 50-50. That the child will be 4.5 then, is that correct?
3.5.
3.5 then, so usually 4 years is something that we take a look at, but let's say put a pretty strong incremental thing up for the next year and get up to 50-50 then, okay?
Okay.
Okay, is there anything else?
No, Judge.
You want to draw the order
Yes, Judge. I
and
can.
carefully submit it so y'all will be in accord with it?
I can do that, Judge.
Run it by Ms. Coleman.
I'm sorry.
Says you need to run it by Ms. Coleman.
Yes, absolutely.
Okay.
And then just for clarification, Judge, we are going to be expanding visitation starting today. Is that correct?
What she offered would be good.
I will say that this Saturday will need to be the following Saturday. They're out of town this weekend, so.
Okay, so we're doing Monday, Wednesday, overnight.
Well,
for
let's
sure.
put that for sure, and then you and I can hopefully get together before next weekend.
Yeah.
And have something else.
And that
for
way we
you.
can have a schedule so y'all can plan to incrementally do it. And if it goes well, we might shorten the year to 6 months, where we try to take it out. Oh, is there anything else?
No, Judge.
Okay, each side will be responsible for their own attorney's fees. Okay, thank y'all very much. Is there
Thank you,
anything else
Judge.
on the docket?
Yeah, we've got adoptions at 2, and then we have a full custody hearing at 2:30.
Oh, thank you.
Everybody's here on the adoption.
Okay, where is the adoption thing?